All right. Good morning and welcome to the channel. My name is Niladri Mukherjee, and I am a regulated Canadian immigration consultant. Sorry for that. I am a regulated Canadian immigration consultant. I practice here in Guelph, Ontario. The topic that I'm trying to address today is called Procedural Fairness Letter or PFL, right? And why is it? Because of late, the number of queries that I am receiving from clients that have received a procedural fairness letter is quite shockingly high. Uh, in the last few weeks, at least, I have received at least 15 to 20 emails from clients that received procedural fairness letter. And unfortunately, in most of the cases, I did not even take consultations because I couldn't have done anything because those were real frauds, right? So let's just try to see what is it when it comes to picture, how to avoid it, what are the typical examples of it, and how not to get a letter. This is not a letter that I'm sure. This is not a letter that you look forward to seeing, right? This is not. This is the letter that you absolutely don't want to see it. Let's just put it that way, right? So what is a procedural fairness letter? Now, if you we just have to backtrack a little bit that we are a country of natural justice, right? Meaning that if somebody tells you that you have committed a fraud, they cannot just tell you that, hey, you have committed a fraud. They have to give a proof, they have to give you reasons as to why they think you have committed a fraud. And in all the natural justice process, they will have to give you some days or some time to respond to their queries, right? So this is exactly where the procedural fairness letter or the procedural fairness thing comes into picture, right? Now, what are the typical examples of procedural fairness letter, or when does a letter comes on your door? If you have committed a fraud, if you have hidden in that in something in your application, if you have incorrectly mentioned something on your application, then you would potentially be banned from entering Canada for the period of 5 years. And before they ban you, the officers most likely will give you a chance to respond. They would most likely want to hear your voice. This is exactly where the procedural fairness letter comes into picture. Now, what are the typical examples of fraud or misrepresentation, if you will, right? Incorrect documents, right? If you have provided a document that is untrue, that is a fraud document, that would lead to misrepresentation and hence a potential ban. But before ban, you would expect to receive a procedural fairness letter. Another example is could be you have hidden something in that application. For example, in if you are applying for a visit visa, if you're applying for a work visa to Canada, you have to mention whether you have had any previous visa refusals or not. If you have had a refusal and if you write no, that I do not have a refusal, that is an example of misrepresentation. They will find it anyways, would potential you will potentially be banned, and but before that you will receive a procedural fairness letter. I also have seen clients where they work with unauthorized local agents, and that agents either willingly or unwillingly have not mentioned something that they should mention in that application, have hidden something, maybe unwillingly, does not matter. It is still a misrepresentation because you have not represented yourself properly in that application, regardless of who actually did that application, right? That would also lead to a 5 year span, and before that, a procedural fairness letter. So anything that is untrue, anything that you hide in that application that you otherwise should not hide, would potentially lead to your ban from entering Canada for the period of next 5 years. But before that, you would receive something called a procedural fairness letter. So this is a one pager kind of a letter that the respective immigration office is going to send it to you, telling you that, hey, I have found that you have either hidden something in that application, or I have found that this particular document is a fraudulent document. This particular information that you have mentioned is an untrue information. This particular IELTS report that you have submitted is a fake IELTS report. And I think you have misrepresented yourself, and hence I would ban you from entering Canada for a period of 5 years. But I am giving you 10 days to respond to that query, to respond to my concern, right? This is a typical example. So, what uh, so who so does it really matter, like if you yourself did the mistake, if you yourself have provided a fraudulent document, vis-a-vis you have worked with an authorized agent, maybe an RCIC, who knows, right? Or maybe an immigration lawyer, that lawyer must have misrepresented your application either knowingly or unknowingly. Does that really make a difference? The short answer is no. You as an adult client, the responsibility lies on you, or you as a client, or you as a potential, applicant for Canada, or you as a potential visitor or a worker or even an immigrant to Canada. The responsibility lies on you to check whether all the right information is being submitted on your behalf or not. So, for example, let's just give you my example, right? If you end up working with me, I'm an RCIC. I always make sure before I submit anything, any file of yours to IRCC for a decision, I provide the complete application kit to you for your final review and go ahead. The responsibility still lies on me to ensure that everything has been provided, everything has been mentioned in the correct manner. But still, the responsibility lies on you to provide you everything, because the file is yours. The submission letter is not my submission letter, that is your submission letter. So I'm legally obliged to forward you all your application kit for your final review. Go ahead before I submit them. But what I hear most often from the clients that come in the consultation is that, well, I did not receive that application kit. I did not get to see my final, application. My agent has written something in that application. My RCIC has written something in that application. Regardless, whosoever is committing that mistake, either willingly or unwillingly, the onus lies on you to make sure that the right information is transmitted. And you know what? Regardless of who did that mistake, you are going to bear the brunt, right? So your RCIC is not going to be banned for 5 years. You are going to be banned for 5 years, right? So regardless of who did the mistake, either knowingly, willingly, unwillingly, it just happened by mistake, I did not want to do it, I still did it, does not matter. The onus lies on you, and the repercussions are going to be the exact same, right? Depending on obviously what the mistakes it, who, like how the mistake had happened and all those things. But I will come to that part in a second. But the responsibility first of all lies on you to ensure that correctly the document is being submitted, your application is being submitted in the truest possible manner. And as I have said, the onus lies on you to check that everything has been mentioned correctly. And regardless of who did it, it does not really have a direct repercussion if you receive a procedural fairness letter, because you have to bear the brunt, right? So what really not to do when you receive a procedural fairness letter? And the reason I'm mentioning what not to do is because 9 out of 10 clients that I have seen having some kind of a knee-jerk reaction when they receive something like that. For example, if you receive a procedural fairness letter, and if the immigration officer has given you a time of 30 days or 10 days maybe to respond to that letter, do keep in mind that you get those 10 days or even 30 days for a reason, right? If they have given you 10 days, there is a reason behind that. If they've given you 30 days, there is a reason behind that as well. You do not, and you should not, I say it again, you should not ever just send a mail to the immigration right after getting that procedural fairness letter saying that, well, sir, it's not my fault, my agent did it, I'm an honest student, I want to visit Canada in the honest possible manner, I'm a law-abiding citizen, this is my mistake, this is my life. It does not matter to the immigration officer, right? As you have heard this term, law will take its own course. This is more true in this case, because no matter whether you're law-abiding otherwise, if you have misrepresented something, again, knowingly or unwillingly, unknowingly, it does not really matter, because the repercussion is the same, right? So it is human tendency to have sort of a knee-jerk reaction, to react to those kind of things in a very, I would say, confused manner. But do not do that. Do not ever respond to that letter on your own right after you receive a procedural fairness letter. What to do? So if you do not have to do this, then what do you really have to do? What you have to do is that you have to introspect, and you have to be honest yourself at that point in time, and have to see and have to really make a decision whether you did that mistake or you did not do the mistake, right? For example, you know that you have provided a fraudulent document, thinking that, well, I may get out, get away with it, right? The officers will not be able to find it. So if you know that you have committed a mistake, if you have provided a fraudulent document, unfortunately, you cannot do anything. You cannot do anything. No point in responding to that letter. No point in engaging with a law firm. No point in engaging with the best lawyer in the world. nobody will be able to do anything. Do not spend your money. Unfortunately, you will then be banned from entering Canada for a period of 5 years. And once you are banned, you will probably find it very, very difficult to get yourself another opportunity, even 5 years after, to enter into Canada, right? So if you have committed a mistake, unfortunately, that is it. There is nothing that you could do, right? But if you have not committed a mistake, if there is a misunderstanding, if there is a lack of judgment at the officer's end, it could happen, right? Humans are human, right? In that case, it does really make sense to come for a consultation. You could come to me, you could go to anybody that you think is licensed. This is very important. Do not go to your local agent. They will not be able to do anything here. Either go to an immigration consultant, such as myself, I'm at CAC, or go to an immigration lawyer if you feel that. Consult, get a legal opinion, and have that RCIC or have that immigration lawyer respond on your behalf rather than you respond to that. I repeat, do not respond to those letters on your own, because 99%, if not 100%, you will not be able to write the response like the way you should otherwise write the response, because there is a legal protocol that you have to follow when you write the response. You will not be able to do that, and this is really your last chance of saving yourself, right? If you have not committed that mistake, right? So definitely come for a consultation, or go to somebody that you think gives you more confidence. Have that consultation done and have that person or anybody authorized to respond to that letter. And if you have not committed a mistake, right, you will be saved. This is for sure. We are a country we are 100% democracy. We do believe in natural justice, and we have no interest, either willingly or unwillingly, to punish somebody if the person is honest, if the person is genuine, right? So if you think that you have not done anything wrong, if you have not done anything for which you should be banned or you should get a punishment, it definitely does make sense to come for a consultation and respond to have that person respond to that letter. Now, here are some tips that you can generally take not to receive the procedural fairness letter, right? Because I'm sure this is something that you are not looking forward to receive. You don't want to receive that, period. Right? Nobody should receive a procedural fairness letter. So what to do to make sure that you do not end up receiving such a letter? First of all, first and foremost, work on that application on your own if you think you're confident, or work with somebody that is licensed and authorized by the government of Canada to work on that application, meaning work with an RCAC or a Canadian immigration lawyer. Before engaging with any professional services firm, an RCAC or a lawyer, make sure to do the validation at your end to check that that the person is licensed, right? Do that validation on your own and then engage with that person. That's number one. Secondly, always understand that as a client, the responsibility and the onus lies on you, and it's your client right, actually, to get hold of the complete application, get hold of the submission letter, get hold of the application, everything, because you understand you will not get access to that RCIC portal. You will not get access to a lawyer portal if you're working with an authorized representative, right? Because along with yourself, there may be 100 other clients that will be represented using the very same portal. So as an RCIC, I'm not legally allowed to give you access to my personal RCIC portal, but I always send everything like a screenshot or the complete application kit to my client to ensure that we are on the same page. And also review your documents. If you think anything is incorrect, make those mistakes, just point out those mistakes, have a brainstorming session, have email exchanges or whatever you think is comfortable and convenient to you before the application is being submitted, regardless of whom you end up working with. Thirdly, and most importantly, do not hide something in front of immigration. If you have had a visa rejection in the past, make sure you mention that I do have a visa rejection. People face rejections, right? It's nothing to be demoralized about. It's nothing, it's not a criminal offense to face a visa rejection anyways. But just be honest in that application, right? If you faced a visa rejection, just mention that I have a visa rejection. Do not ever provide a fraudulent document. I see a lot of cases where the company doesn't exist, but yet there is an offer letter from that company. Understand, immigration is way more smarter than you and I. They are looking to those, looking at those documents day in and day out for years, and those guys are sitting in those positions for a reason, right? So do not try to hide anything from immigration, and do not provide a single fraudulent document. If you are not sure as to what to take in that application form, what to write in that application form, in the specific field in that application form, consult with a licensed professional. If you're already working somebody, then the person might be doing that application at his or her end anyway, so make sure you take a look at the final application. But do not ever provide a fraudulent document thinking that I may get away with it. 99.9%, if not 100% of the times, you will not be able to get away with it, and you will be banned, right? So do not make a mistake, do not provide anything fraudulent, and you should all be fine. But as I've said, if you've provided anything fraudulent, then probably there is nothing to be done. You will be banned. But if you are banned, you could still come to Canada. Within that 5 years' time, there is a process called TRP, temporary resident permit, through which you can still can come to Canada, and can even become a permanent resident if you hold the TRP. It's not for everybody. It's a very complicated process. And obviously, just a single video will not be helpful. You may not have to come for a consultation, but you don't want to go for those kind of complications. Be honest, provide everything genuinely, and you should be all fine. And always do remember, a Canadian visa is your privilege, it's not your right. So we always have to be respectful, we always have to be honest while we make that application, and you should be all fine. If you need my professional assistance with making sure to submit a complete application, to making sure that everything has been done properly, if you want me to consult you, come for a consultation, review the website www.nuvonation.ca/professional consultation. Send us an email, contact@nuvonation.ca. I shall be glad to consult you. And I see a question here, which is what to do if the actual dates I'm supposed to travel in my letter of invitation get over before they approve my file. Well, this is a very typical situation these days, wherein you should ideally put a date which is reasonably ahead. And if they still, your date is passed, it really depends on how that application has been made. There have been cases when they reject an application saying that your purpose of travel does not meet. But I have also seen the cases where the submission letter has been very strong. They have accepted the application. So it really depends how that application has been made, what is the date for, how long uh, before you have actually made that application. So I really need to see all those details before I could suggest something. But if that application has been perfect, if that application has been done properly, I do not see any problem in there. I hope you find this helpful. I will see you probably in the next video. Bye now, guys. Have a great day ahead.